some point,
Don Littmanson, what happened in court?
what happened was that Christopher Diaz was picked up by the extradition agents from Texas this morning. So when we went to court, he couldn't be there because he's been taken out of the jurisdiction already. I went to the jail this morning intending to talk to Chris, set up an appointment with him a few days ago. And what I was intending to do was get the details on Chris's assertion that he was not allowed to exercise his right to represent himself under a right that's guaranteed by the Sixth Amendment and the U.S. Supreme Court. Somehow, it's not very clear exactly how this happened from the court records, but somehow the public defender's office, someone in the public defender's office seems to have taken a role just beyond just acting as his advisory counsel into actually delaying some of the proceedings and getting a continuance rather than having the extradition matter move along in the relatively short statutory deadlines. This happened before I came into the case. Once I came into the case, it started to become apparent to me that there may be some grounds for a habeas corpus relief, at least temporarily postponing his extradition. First of all, his health has periodically been very poor. Over the last couple of days, he's developed what I'm told is a very extreme toothache that looks like it's from a cracked tooth that's perhaps abscessing. And most importantly, from a legal point of view, was that the Penal Code gives people, even after the governor's warrant has issued, a certain amount of time to bring a habeas corpus application to challenge the lawfulness of the extradition. If you ask to be your own attorney, as long as you are competent, even if you're not skilled enough in the eyes of the court to be your own attorney, you are entitled to represent yourself. And it seems to me that that's basically what Christopher Diaz was trying to do from the outset. And yet, at no point, despite a couple of requests on my part, was the extradition ever stayed for a brief period of time in order that we could develop the facts and present the court with a habeas corpus application. And I feel that this was error, that if a judge had had the opportunity to review, to listen and hear the arguments today, very likely we would have gotten enough of a delay to pull together the documents in an attempt to prove our point that he was denied the right to self-representation. But because he's no longer in the jurisdiction of Mendocino County, that matter is now moot, and there's no opportunity for us to bring a habeas corpus here. I'm feeling both disappointed and rather depressed at what I view as the breakdown in the system in terms of us not having gotten the time to be able to bring the application for habeas corpus, which the Penal Code and other authorities, legal authorities, say is routine in a situation like this. If Chris had been here a few more hours, we would have been able to get this in front of the court. And I would like to believe that the judicial system is sufficiently concerned that they would have taken our request seriously.
Last evening, he relayed to me, he actually read to me the statement that he was going to read in court today. He's been preparing a statement about what has happened to him here in this court system, how he had requested to be his attorney from Judge Ann Moorman at the first hearing. He stated that he wanted to be his own attorney and requested the documents that he would need, whatever the legal statutes, everything that he would need to do that. And at some point, this Andrew Higgins got put on to him as a side counsel or advisory counsel, but then just took over. Well, we've been through this with the Marsden motion. It's the same thing that he was saying before the Marsden motion. I've got all of the paperwork here. I've got the entire Section 50 on extradition from the California Criminal Procedure and Practice Manual, Witkin. I've got it here, and I'm reading it. And these are the things that should be done. First, we need to contact the District Attorney, Michael Murray. Then we need to contact the governor. There are things that we should be doing from the very moment to resolve this matter. He's been painted in the court here as being uncooperative. This is just not true. It's just not true.
What else was he going to tell the court? Had he been given that opportunity he's been waiting for 90 days?
Oh, he was going to express to the court. I'm sorry.
There were a number of things that needed to have been done right from the outset that would have made it a lot better for Chris, I believe. The DA in Brown County should have been contacted within a few days. I contacted him within about 5 days of coming into the representation because it hadn't been done already, but by then it was the DA had clearly made up his mind that Chris had to go back and either directly or through a lawyer negotiate with the DA in Texas. So that decision had been made. I think had it been done very early after Chris had been taken into custody, there may have been more flexibility.
The DA used harsh terms to characterize that.
Yes, and I don't think that's
mano to mano, something like that.
Well, the DA used the term no, man to man. I don't know that that's
I got to go across the street
necessarily more than a colloquialism. It's not an expression that we might be using here, but I'm not sure that is more than a statement that Chris has to be here and talk to me, and we'll see if we can work something out. But I'm also concerned that the deputy public defender to whom this case had been assigned for a number of weeks didn't do the things that Chris's mom is describing. They ought to have been done, and very importantly would be to have notified the governor's extradition department that there was an attempt in progress to negotiate a solution, and that they were looking for a way also for Chris to be able to go back voluntarily to Texas to surrender and deal with it there. There are a number of really unique factors here, like his sickness, his chronic and severe and debilitating asthma, and the very small quantity of cannabis that was involved, that quite possibly the Attorney General's Office of California would have communicated with the prosecutor in Brown County and been able to work out a resolution. It's pretty apparent to me that the district attorney in Mendocino County, the deputy or the senior deputy who was handling the matter, didn't do that. Now, I could be mistaken, but he's never indicated that he had made any effort to seek some involvement of the governor's office, and that's discretionary in his part. But I'm disappointed that there wasn't more of an effort to settle what really was not at all a very significant amount of cannabis, and that for that Texas is having to go through a lot of expense. Chris has some responsibility for the expense by having left the state when his proceeding was in process, but that doesn't mean that we couldn't have worked out something that would have been quite possibly satisfactory to both sides had it been dealt with here earlier in the case.
Where was Chris in his case when he left Texas, Nona?
His case had been rescheduled. He had just taken on representation of himself to act as his own attorney in Texas. He was given about 5 weeks to prepare to defend himself against a possible life sentence for a ½ ounce of cannabis that's legal in California.
Even the concentrated cannabis?
Even the concentrated cannabis is 100% legal in California.
Which pushed it into a felony, though, in Texas.
Yes, in Texas they do not recognize that he is a medical patient, that he lives in California, that he was merely traveling through Texas with no intention of ever staying there, that he had left Texas, that he had moved from Texas as a minor child on the recommendation of a doctor from Texas to move, that he had moved to California and become a citizen of Mendocino County and has lived here and is perfectly legal medical patient here.
Did you assist him in his decision to leave Texas? Did you know about it at the time?
Yes. Yes, absolutely. I've assisted him from birth. He's been sick since birth, and I've taken him to the hospital, to the doctor, to the pharmacy, repeatedly, in any attempt to help my child. Did I assist him to
Leave Texas to return to Mendocino County?
run away, or because he didn't really run away? There were no stipulations on him that he couldn't leave the state of Texas. He was never told you can't leave the state of Texas and go home to hire attorneys in California or to seek help there. He merely missed his court date. They've turned it into, oh, he's on the run, Osama bin Laden, he's probably hiding in a hole somewhere. They've turned it into this big thing. He merely missed his court date, which could have been rescheduled. The district attorney, Michael Murray, has been unwilling to reschedule that court date, instead saying that he's on the run and refusing to abide by state, federal, and local laws, which is just it's absolutely not true.
Did he make attempts to reschedule from here, that court date from here?
Yes, he did. Yes, he attempted many times to contact Rudy Taylor, who has been appointed to him there in the Brown County Court as his liaison to the court to actually do those things for him. Because he's not a lawyer, because he has no legal training whatsoever, he doesn't know the legal ease and the way to communicate with the court. So Special Prosecutor Rudy Taylor was assigned to him by the judge there, Stephen Ellis, to be his liaison to the court, to go back and reschedule these things or whatever needed to be done. What you can do to help, send money. Money is what will save my son's life. $168,000 would have saved his life here in Mendocino County. $168,000 bond. If we had had $168,000, he would not have spent 9 weeks in solitary confinement with declining health to the point where now he can't breathe, he can't swallow, his neck is swollen, and they take him in the middle of the night to a death sentence in Texas. Money will save my son's life.
What are you trying to put together?
Right.
Immediately.
Immediately, enough money to hire a lawyer. $7,500
is what the lawyer has requested, and where should people send these funds?
Okay, we don't have anywhere for anyone to send the funds right now. We plan on traveling to Texas to hire a lawyer there. We're actually already in the works. We've been speaking with the lawyer, our California lawyer here, Donald Whitmanson, has been in contact with the lawyer there. And we're raising funds for that lawyer and then the travel to Texas.
There are many ways that you can help Chris. You can go to his website at www.free215chris.com. You can get on Facebook and search for Chris Diaz or Free Chris Diaz, or it's facebook.com/stop215extraditions. You can also go to PayPal directly and use stop215extraditions at yahoo.com as a recipient address. We're going to set up a bank account that you can actually send checks to or deposit cash funds to. So we'll keep you updated on the free215chris.com website. Thanks.
And you can also write to Chris and send him books through the mail. Softback books is what they're allowed. Directly from the publisher, I believe Amazon, you're able to order books and send them through the mail to him, or cards or letters, whatever you'd like to send. You can get the address information at the website www.free215chris.com and where to send that to.
And what are your aspirations this day after your son was grabbed on your birthday from the Mendocino County Jail by officers of the state of Texas?
We didn't expect it. Chris had a hearing where he had a lot to say, and unfortunately he wasn't there to put it on the record. His attorney did get some of the things on the record that needed to be said, so it's not a shut case here. Texas just came in and snatched him up, and with that, like a thief in the night, and so it's time for us to head to Texas.